Hello, everyone. It's wonderful to be taking part in the Brazilian Trademark Office international event. Definitely the most important instance in intellectual property in Brazil. And now is the time to discuss sensitive topics, innovative topics, and the future of what can be expected in terms of intellectual property. This panel will be addressing one of such topics. This is a new issue. It's an issue that has been causing a lot of debate in the judicial branch, and Brazil is becoming a key player in that debate. Brazil is now one of the fora where the discussion on essential patents and the exercise of essential patents has been a very, very present topic. Also discussing its future. And why has Brazil become such an important topic for this debate? Because these debates on essential patents, which are standards in the industry, especially in telecommunication and IT, are local disputes, are global disputes, sorry. They are disputes between patent holders, patent portfolio holders, or technology implementers, and the debates happen globally. The litigation usually starts in developed economies, but Brazil, as a country that has been making progress in that area, has industrial activity and a relevant market, is beginning to see that litigation coming to our shores, especially because our injunction regime is more flexible to the granting of injunctions more than other more strict countries. So injunctions obtained in countries such as Brazil can be an important tool when seeking a license or when seeking to monetize on these patents. So today we will be discussing these topics, their main facets. So first, we will hear Mr. Nicholas Gayet and how things are developing in Germany and in Europe, and then we'll have the pleasure to listen to Judge Flavia Romano talk about the Brazilian court situation, its repercussions and consequences. So we'll start with Nicholas. I will briefly read his bio. Nicholas, I will be reading your bio in Portuguese if you allow me, and then I will turn it over to you. Dr. Nicholas Gayek is a senior partner at the litigation team of intellectual property at Neue law firm in Germany, which he joined in 20. At Neue, Nicholas works on litigations in complex patent lawsuits, mainly in essential patents. A large part of his current work focuses on communications technology, but he also has vast experiences in other areas, such as overlay technology. Nicholas's knowledge includes competition law and the protection of trade secrets. He holds a PhD. Nicholas helps different clients in different areas and deliver talks on trade secrets and patent protection. He's also a member of the Permanent Committee of Standards and Patents at ABPI, and I remind you that the Congress will happen in San Francisco a few weeks from now. If you haven't had the opportunity to register, now is the time, and many other intellectual property organizations, such as the German Association for the Protection of Intellectual Property. Over to you, Nicholas.
Thank you so much, Luis Enrique Dormeral, for the kind introduction. And thank you all for attending today for this special topic. So we have had SAP litigation around in Europe in particular since the end of the 1990s, actually, and we had first decisions by the European Court of Justice, for example, in the cases such as IMS Health, in those years. And it has really developed over the last 20 years or so, reaching, for example, the now famous decision of the European Court of Justice in 2015 in the case Huawei versus ZTE. But let's start at where we are right now. What actually consists? What makes an SEP an SEP? So essential technology is always a matter of a patent, of course. We always have a specific technology incorporated into the patent, and the standard component and the component that we really are going to discuss today is actually the commercial value and the commercial exclusivity that is derived by the patent. That makes an SEP special. So we have a normal patent that is relevant to a standard. So standardized often means incorporated into a technical standard, and that is an act of formal standardization, as can be seen, for example, in the telecommunications industry, for example, 3G, 4G, 5G. We all know these standards that we all use on a daily basis when using our mobile devices. They function all over the world because everyone is using the same technology, right? But that's not the only case where we are talking about standard essential patents. It could also be, for example, a single market participant holding one essential patent, controlling access to a particular market. We had this decision, for example, in the Federal Court of Justice's decision in Germany, Standardsbundfass, which was in the mid-2000s actually. And the relevant patent related to a barrel, a specific barrel that was used in the chemical industry. And since everybody used it, even though they might have been able to use other barrels as well, this specific patent relating to the barrel actually constituted a standard, a factual standard, and leading to the conclusion that it actually also was relevant under competition law. So we've seen there's actually no particular specific way to derive a standard essential patent. It's often done through standard setting organizations, but it doesn't have to be. If it is derived by a standard setting organization or by any other cooperation between enterprises that are otherwise competitors, we are already in the sphere of competition law. In particular, in European Union law, this is regulated by Article 101 of the Treaty on Functioning of the European Union, which is the basic antitrust provision. So, in exception to the antitrust provision, we have an allowance for such cooperation if, but only if, and that is, for example, regulated in the European Commission guidelines on the applicability of Article 101 TFEU. We have a transparent procedure for the adoption of the standard. We have opportunities for third parties to participate. Then the standard must be in principle non-binding in nature. And we need third-party access to the standardized technology in fair, reasonable, and non-discriminatory terms. And that is these provisions that actually, they must be considered and they must be applied when the standard is created. So we're not yet at the litigation side of things. We're still very much in advance, simply discussing how companies are actually allowed to come together to form a standard. So here we encompass several problems. As we have heard earlier, our main issue is that the standard rarely really discloses every patent that is relevant to it. And it's hard to tell which patents are actually relevant to a standard. For example, several companies might be part of the standard setting process, and each of these companies might have 50 or 100 or so or more patents. And then afterwards, after the standard is concluded, they are assessing themselves whether or not this technology is actually relevant to the standard. And this might lead to over-declaration of patents, which is our problem number one, laid out here. Since some of the patents that the company holds might not actually be essential to the standard. They might have been left out during the standardization process, or they might address a specific issue that that may even be incorporated into the standard, but it may be part of the standard that is not relevant, that must not be implemented necessarily to products. So this is the first issue. The second issue that we can see is the problem of funding, and that actually is a problem on the licensing side of things. So even if you have a portfolio of 10 patents, and all of these patents are relevant to the standard, you might not be willing to license it as such, but you would put it in a bigger bowl, in a pool of patents, where you would also put in, let's say, 20 other patents that relate to the technology but are not necessarily part of the standard. Which, of course, can have advantages on the royalty side of things, and it does make the situation much more difficult for the defendants. Because the defendants, they often have no detailed knowledge of all of the standard when they first are confronted with it. And then they have to figure out themselves which patents are actually relevant and which are not. And often, they are often in a situation where they can either take it or leave it and have no other chance but to license all of these patents. And that way, often patent holders can actually provide licensing agreements relating to patents that are not as relevant for a higher royalty rate. So we have some potential solutions for issues such as this. Of course, you can always do a commercial standard essentiality analysis, for example, as a defendant who is confronted with patent infringement claims out of standard essential patents. But that takes a lot of time, and it is costly, and it's not always correct. Then there's, of course, a procedural approach, and you can test the patents and really thoroughly analyze them while defending against infringement claims. But this, of course, only applies to patents that are actually asserted. And generally, most of the patents that are part of a portfolio that is offered to you as a defendant, for example, in a patent infringement case alongside, is not actually litigated. So that's also not a solution that will generally help you in all cases. Then I will come to that back later. There's possibility of competition law action. There's claims that an implementer, a willing licensee, can bring even without having been targeted yet by an injunction case, for example, by a complaint from a patent holder for a standard essential patent or non-practicing entity asserting such patents. And then, of course, there's always big question, legislative action could address some of these issues. Hasn't happened yet on a broad basis, also not in the European Union or Germany. And so we're still waiting for rules from the legislature that would actually cover the issue of standard essential patents, I'd say. So let's have a look at SEP infringement claims. Generally, SEPs are just patents, and we see all of the claims that actually can be derived from a patent also being derived from an SEP and an SEP infringement claim. So remedies, of course, include cease and desist, damage claims, information rendering of accounts, recall and destruction, you name it. But the big thing about SEP infringement complaints or SEP infringement litigation in Germany in particular is, and this is different in some other jurisdictions, is that due to standardization, the courts may actually assume patent infringement based on the standard compatibility of a product. So what does that mean? Usually, if you're asserting a patent, you have to show that the patent is implemented in the attacked embodiment. If you have a standard essential patent, it's often the case that the products are advertised, for example, let's have a look at the smartphone as being 5G compatible. So we want to buy the newest smartphone, of course, the vendor will tell you, well, it can do 5G. So that is established. And on the other end, what the patent holder is trying to establish is that the patent is actually relevant to the standard. And if those two criteria are met, so patent is relevant to the standard and the standard is in the product, then German courts tend to say, well, the patent must also be part of the product. So that is an assumption that is derived from the standard essentiality in the end. This could also be different. For example, it may be that the patent is relevant to the standard, but for technical reasons or because it's just not the most essential part of the standardized technology, it is left out during implementation. And that is a defense that can also be brought by the defendant. But because of the assumption, it's really a relief that is granted to the patent holder. Because the patent holder doesn't have to show that the patent itself is implemented in the product. He doesn't have to show how it is implemented. He only has to show that patent's in the standard and that the standard is in the product. So, and the big thing is, of course, for defendants, the front defense. So defendants are always able to raise the legal argument of abuse of market dominance, which is under European Union law, Article 102 Treaty on the Functioning of the European Union. So the principal legal basis for this claim is the idea that the patent holder, he has the possibility to grant access to the market or not. And by granting access to the licensing market, by granting a license, he's able to actually allow the implementer to also produce the product and sell the product, and so the patent holder has actually a controlling position also over the downstream markets. So if the implementer does not have the option to take a front license, and we've already talked about this concept shortly beforehand, fair, reasonable, and non-discriminatory license relating to the standard essential patents that are used in their products and necessary to be able to produce and sell these products, then they can raise the front defense, and the front defense means that the complaint will be dismissed as, at the moment, not founded. This is basically a good faith argument in the end. So, but the front defense doesn't apply for all claims, because of course you always have to take a license on front terms as an implementer. You're not allowed to just use the patent, you must pay for it. So what you can actually fight with a front defense are foremost cease and desist claims, because the patent holder is always required to offer you the license. You should be able to sell your product, even though it incorporates the standard. And this is why you can basically raise the front defense against a cease and desist claim, against damages that go beyond the front license fee, although this is a controversial issue, because you're only obliged to take a front license, so pay the license fee for the device and so forth, but you're not really, in general, liable, for example, for other damages, which you might actually enforce in normal patent cases. Same with information rendering of accounts. You are, of course, as an implementer, always in a position that you have to provide information specifying, for example, how you come to this front license fee that you have to pay. But you won't have to provide any information beyond that. So, as far as information claims under normal patent law are broader, you can also raise the front defense. And on the contrary, we have no front defense against damage claims relating to front license and information rendering of accounts as far as they self-specifying damages out under a hypothetical front license fee. So, what are we actually checking when we do the front, when we raise the front defense? What will the court actually look at? And there's a couple of steps that are specified in the decision. I already named CJEU, Huawei versus ZE, so European Court of Justice decision. And there's also some very recent precedent from the Federal Court of Justice in Germany in the case of Siskel versus Haier, which build on the precedent from the CJEU. And it's basically, in very simple terms, it's a 5-step test. It always begins with checking, is there an infringement notice? And that is a big difference, for example, to compulsory licensing proceedings. Because under German law, a compulsory license can only be reached if you, as an implementer, reached out to the patent holder prior and asked them. And if they deny your license and so forth, then at some point you can request the court to grant a compulsory license. It's different in SAP cases. In SAP cases, it's always the patent holder who has to inform you of your infringement first. And that makes a lot of sense, because if you, for example, look at the LTE standard, which consists of tens of thousands of patents, no implementer in the world, no, for example, smartphone company knows all of these patents. And therefore, it's only logical that it's on the patent holder to inform you which patents you allegedly infringe. And upon that infringement notice, you're required as an implementer to declare willingness to take a FRAND license. And that means FRAND license, whatever FRAND means. It may be that you don't even know what the license fee will be at that point, because you don't have the information as the implementer, and you have to find that out first. And if you declare your willingness, then it is again upon the patent holder to provide you with an offer. And the offer must be well-founded. What is often used for that is, for example, comparable license agreements. So if the patent holder already has license agreements in place with other entities, with, for example, competitors of yours covering the same portfolio, then these are often looked at also by the courts in Germany to consider whether or not a license offer made to you as an implementer and defendant in the respective case is FRAND. And if we have that offer, and if you still deny that offer, you're still allowed to say, no, I don't want to take that offer as an implementer. But then you will have to provide a counteroffer, and it also has to be well-founded. You have to find your own reasons for that. There's always a lot of variety of arguments that you can draw from to found your claim, actually. For example, there's also top-down calculation that you could use, meaning that you actually look at the whole amount of patents that there is under the respective standard, and the whole amount of technology that you're actually using in your product. And of course, license fees can only be a small proportion of the revenue that you generate with your product. And the license fees for that particular standard can also be a small portion of the overall license fees, meaning that you can actually calculate basically a maximum that you could pay for the license for these particular patents. That's in my opinion, it's a very good approach to actually kind of check whether or not an offer made to you as an implementer can be FRAND. But it's not one that is always adopted by German courts, to be honest. They often rely on comparable licenses and claim that they don't really have the whole economic picture necessary to really do a calculation, a specific calculation of what is FRAND. So let's say you're implementer, you've provided your counteroffer, and then the plaintiff says, and the patent holder and plaintiff says, no, I don't want to take that. Then, according to the logic discussed earlier already, you have to provide a bond. The bond actually consists of the amount of license fees that you would have to pay under your counteroffer. Because you've already used the standard, right? You've used it up until now, and that is why the patent holder is actually pressing forward with an injunction. Because they're saying, well, you're using my patent. And you're saying, well, I'm willing to license it, and I'm willing to take a license, but it must be FRAND. So now you actually have to show that what you consider FRAND, you're willing to pay. And if all of these conditions are met, then you have a good chance of succeeding with a FRAND defense, and that is, of course, a high burden, and it consists of a lot of steps of both parties. And because it is such a big feat that it requires implementer and patent holder as well to contribute, the German courts actually went a bit further. And they kind of created another feature by saying, well, you have to always be willing to take a license, meaning you have to negotiate in good faith and negotiate speedily and so forth. And if one of the parties doesn't meet that requirement, for example, as an infringer, if you really don't respond to an infringement notice for a longer period of time, then the German courts might simply say, well, obviously you're not interested in taking a FRAND license, so we're not giving you the FRAND defense. And they don't really look at all of the other criteria, which may be a problem if you look at CJU, Huawei, ZTE, the decision, which created these requirements. But they don't really look at that anymore, and they say, well, you're clearly unwilling. On the other hand, you might say the same about a patent holder who hasn't really approached the infringer with, or let's say the implementer with an infringement notice. And the patent holder, if they simply raise cease and desist claims without actually informing you of infringement, giving you time to negotiate, they might as well be considered unwilling to actually grant a FRAND license. And it might be the case that you're even granted the FRAND defense. We haven't had this case yet, but it might be the case that you be granted the FRAND defense without the court checking all of the requirements. Because of them simply saying, well, you're obviously, patent holder, you're obviously unwilling to take or to give a FRAND license. And of course, considering the special requirement of willingness, but also all of the other relevant steps laid out by the CJEU, there's a lot of open questions. For example, relevant detail of notices, offers, burden of proof for the founders of an offer and counter offer, who actually has to provide how much information, further requirement of willingness, how do you actually assess that? There has been a recent decision, for example, I won't go into the nitty-gritty by the Higher Regional Court Düsseldorf on that very recently in March this year. So, and the list goes on and on and on. Of course, as a defendant, you don't only have the FRAND defense. You can always raise counterclaims or even preempt an injunction or a complaint by the patent holder, for example, by suing for a FRAND license. That is also an option. And there's the big question of SAP licensing in the value chains. Many of you might have heard of, or some of you hopefully have heard of the decision Nokia, or the cases Nokia-Daimler. There has been a few decisions in Germany, and then the decisions were brought to the Federal Court, to the European Court of Justice, actually, to answer some fundamental questions on licensing in the value chain, meaning if I, as an implementer, get the product from another company that is actually infringing the patent, the standard essential patent, can I rely on that other company being willing to take a license, or do I have to take a license myself? So that's basically one of the big questions that's already been raised, but still unanswered. And then we have a lot of adjacent issues relating to territoriality, for example. Some of you may have heard of anti-suit injunctions, anti-suit injunctions. So what do we do if actually courts in different parts of the world set global FRAND rates, and they have different opinions on what is FRAND, and they might come to different conclusions, for example, relating to the FRAND defense and so forth. So these are really big issues that go beyond what we had before in patent law. These are issues really related to the standardization of the product, of the relevant technology. And these are issues that, even though we have dealt with this for 20 years or even more in Europe, we haven't really found conclusive answers to yet. And I think the same is true for many other of the big markets, for example, United States or China, which are also dealing with the same issues over and over again and are really struggling to lay out further criterions or definitive way to resolve these issues derived from standardization. So, so much for a short, specific, still broad overview. And I'm looking forward to hear what has been happening on the Brazilian side. Thank you.
Regarding how this is viewed in Germany and Europe, without a doubt, we will go back during the question and answer phase to other correlated questions that we will deal with. And now, so that we can hear the Brazilian side and the vision of the Brazilian legal system, represented by Dr. Flavia Romano here. We're going to give her the floor, but first of all, I'd like to introduce Flavia briefly. She is a judge of the Court of Justice of the State of Rio de Janeiro, has a master's degree in public law. She's the president of the Rules and Legislation Commission, president of the Coordination of Districts in Debt. She is part of the Institutional Policy Commission for the Budget Administration of the Court of Justice of Rio de Janeiro. This is just a summary of her extensive CV. You have the floor, Doctor. Can you hear me? Okay, so thank you very much for this introduction. Good morning to all of you, ladies and gentlemen. I wonder if I should stand up or speak from this chair. I think I can manage. Otherwise, I can look at my computer here. I would like to thank the ABPI, for inviting me. There's so many friendly faces that I see in the audience, and I also managed to chat with people outside. I hope I'm not forgetting anyone. I'd like to thank Gabriel Leonardo, the president of ABPI, for inviting me. It is a challenge to be here speaking about this new topic. I mean, in Europe, they've been discussing this for the past 20 years, and we're just starting here in Brazil, especially for the Brazilian legal system. This is very new, and there are so many questions. I've prepared this PowerPoint, but I'm not an expert, so the slides are very busy, and I apologize for that. I will try to outline a legal framework of essential patents to understand how the Brazilian court system has dealt with this issue. So you can stop me if I'm speaking too much. That's every lawyer's dream, to make a judge shut up. So there's nothing that is absolute, definitive, or right regarding essential patents. I will briefly speak about the difference between patents and essential patents, and both these topics have been approached by Nicholas, and this whole legal framework in Brazil about this topic. And there's some decisions from the Brazilian CAD. The CAD is a Brazilian competition protection office, and so you all know that we have to compensate inventors for the time and resources put in. And there's also the monopoly, which is an objection to competition rule, which is to prevent other people to use this invention without the authorization of the holder or the inventor. Lawyers always like to make matters more complicated. So essential patents would be a standardized technology, and then it becomes complicated. So let's start out with a simple definition. And the doctrine defines standard essential patents that I will call SEP or SEP. These are inventions that implement a technical standard that has to be complied by all players in the market that want to produce a product according to that standard. These patents cannot be avoided, and they cannot be avoided by companies that want to produce a standard compatible with that technology. We know that patents are territorial. They have to be assured in their territories, and patents can be wholly essential or essential in just one or more than their claims. And why do we speak about essential patents? Why do we make this distinction? Over the past decades, what we have noticed that the useful life of technologies is very short. Furthermore, the economy has been growing on a network fashion or shape. There are niches, and there's a growing number of users, and then two keywords come into play: interoperability of products and sharing of technologies. They're both fundamental. Well, we will speak about some disadvantages for the inventors of these essential patents, but the important thing now is to focus on the advantage. The sharing of these technologies is almost a springboard from one technology to another. You do not start from scratch. You start with an existing technology and you move to a more advanced one. You have greater security, a larger number of users. There is profitability for whoever holds the patent. And I've brought you some examples about these essential patents. I will try to change slides and hold the microphone and do all of these things at the same time. Anyway, so who sets these standards? I'm fine, thank you. I was going to bring a copybook with me, but I thought that, there were not enough hands. So who sets out these technical standards? Nicholas has spoken about the standard-setting organizations. They can be public, private, national, international, and their purpose is to introduce all of the steps in disclosure, interpretation, revision, and change of technical standards. The European Commission raises an interesting topic, namely the holder of the patent has restrictions of his intellectual property rights, but there's also advantages. This has to be a win-win situation. And some examples of these standard-setting organizations are the IEE and the Brazilian Association of Technical Standards, the BNT in Brazil, there's ISO and several organizations. And the holder of that invention can claim that that patent is essential. We will see how the court system has been dealing with self-claims. When a technological standard is developed by one of these organizations, it can and should make it compulsory for members to disseminate information about what is the scope of that technology, what is being claimed as an object of that patent, and the result comes as the issuance of essentiality. Once these standards are defined, how are you going to grant this from the licensor to the licensee in the market? I have some friends who sent me different opinions to read about this matter. They were all so pertinent, and they talk about a legal structure of sharing this information, almost a guideline, almost a code of conduct for sharing these technologies, which have to be complied with. And then we talk about licensing. Nicholas has spoken about this, but I'd like to talk about Brazil. Professor Zecam says that it wouldn't actually be a license. The application of Article 61 of LPI, and it is not just granting an IP right to a licensee by the payment of royalties. It is a cooperation pact. It goes way beyond this concept that we call a license. And what are these FRAN licenses? We've already defined what FRAN is. What is fair to us? We've talked about equity, about the adoption of non-competition rules or abusive rules to a company that dominates the market. And what do we want with this fair? To push away a coupled license, the possibility of licensing an essential patent, and to license others that are not in the same package. We've spoken about bundling. And so I grant an essential patent to you, and you give me a license to me for free. These are practices that should be avoided. And here there's a practice in law, and I know that lawyers don't like when they have meetings with me. I make many questions to them, which upsets them. But I think that there's an important article, which is 442 of the Civil Code, which is good faith. Good faith should guide all of the negotiations and the posture of these players in the market. You have pre-negotiations, you have negotiations, you have a conclusion of a contract and contract execution, and good faith has to guide this process throughout, as well as ethics and probity. Good faith should be a base principle in law. As a judge, it is not what I see in practice, but to me this is crucial. When I see that a party is in good faith, a lot of progress has been made. And for foreigners, international doctrine stipulates that faith is the non-imposition of inadequate restrictions for the exploitation of a given technology. And what is reasonable? I'm reminded of a lecture by Leonardo, who said it is very difficult to determine what is reasonable. So if it is difficult to him, imagine to us judges. There has to be some kind of a balance in the charging of these royalties. What is the calculation base? How do you make the maths? These are difficult issues, but there's the weight of the technology that patent has in paying for the holder. The holder has to be sufficiently paid for. This is crucial. And to bring you some of our legislation, you have the interpretation of contracts. Article 113 of the Civil Code also speaks about good faith. There is the non-practice of illicit procedures in negotiations that push away the possibility of committing crimes, and there is the social protection of contracts. And this is very important in our law. This is not seen in the same way abroad as it is by judges here. Judges see the application of the consumer code rules as something that is very important in analyzing these cases, and there is a repercussion in this war of injunctions. When you take a competitor from the market, there is a ripple effect in society. There is an opinion of Professor Eloisa in the ABPI magazine about these issues, that an opinion has to be read by everybody. It is crucial to understand what is the ripple effect for users in the consumer's market when there is a war of injunctions. And the participation of these users, the scope of these technologies, increasingly serving users. Non-discriminatory is to treat everybody likewise, or isonomy. Royalties in Germany will not be the same ones in Brazil because of social and economic conditions which are different and have to be taken into consideration. It's been said before, but I thought it was very important to bring this roadmap of the European Commission that laid out possible parameters for FRAN licenses. This is all based on this good faith code of conduct. The increase of transparency and FRAN licenses create a legitimate expectation on licensees, and also the issue of whether people could have an injunction without violating anti-competition rights. Now, talking about Gabriel's lecture, he said that in China, those who are part of a negotiation adhere to those terms and should not go to court asking for an injunction to take a competitor off the market. In Brazil, the situation is different, but This is part of our cultural differences. Now, talking about the legal framework, there you have to have a balance established. And on the one hand, if you have the protection of the right of exclusiveness of a patent that is granted in Article 5 of the Federal Constitution, granted to the authors, temporary privileges. On the other hand, you have an anti-competition regime that goes against abuse of power. Article 41 of the LPI gives the holders of patents a series of rights, but which are not absolute. They are limited, and the court system has to understand these limitations in the case of essential patents, and this is not being taken into account, and I include myself to blame here. But these limitations, there are some who said that there is a predictability for essential patents and the LPI, which is compulsory licensing. I don't agree, but they speak about an interdependence of patents, especially in Article 70 of LPI, and you have limitations against competition. Article 173 of the Federal Constitution speaks against the abuse of economic power and elimination of competition. And then we go back to the issue of users who are also affected by anti-competition rules. I'm not going to talk about the patent rule because Nicholas has already spoken about that. That will be unnecessary of me. There's a lot more in this matter. Non-discriminatory is equal treatment or isonomy. And here the doctrine speaks about an interesting topic, which is being used by lawyers in court, which is those who are part of the FRAN licenses, the archetype of FRAN licenses, which is to be like, I participated in this, but this is my competitor. I will not negotiate the terms of this license with him or her. So the licensee sometimes has been granted the right to contest if they're not part in this business, if he or she is not given the possibility of accepting the terms of the FRAN license. If there is compensation to be paid, something that you love, and I think that everybody loves in law, is legal nature or juridical nature. To us, this is very important because since there are no regulations, no standardization in Brazil, the concept of the legal nature of essential patents is crucial. Some speak about the collaboration pact and an association contract. I think that the association contract makes a lot more sense. We should always talk about cooperation and sharing, the exchange of technologies in thinking about a better society in a win-win situation. Now, the worst scenario is the injunction war. My time is almost up. I am going to speed up here. He is interested because he wants me to say bad things about the court system. I shall do so. I can say anything here, right? Okay, so off we go. Ericsson. We have several disputes of Ericsson internationally, and in Brazil this would be no different. What I think is extremely interesting is that the U.S. Court of California has taken up the responsibility of stipulating the conditions for a global patent license. Imagine if the Brazilian law or sort of court system would be granted the possibility of doing something similar. I'd love to hear what lawyers would say about it. So there was a suspension of these lawsuits because of this international adoption of this responsibility of laying out the responsibilities of this global license, and the parties suspended the suits. What is the negative consequence of this for everybody? I cannot see this being positive to anyone. The second business district of Rio determined that the terms of the license were not complied with. It granted an injunction about the sale of products, and there has been the injunctions have been going back and forth, and this is a struggle that only brings uncertainty and problems, and nobody wins with that, apart from those who speculate about it. I have some sentences here of CAD, which is the Brazilian Competition Authority, antitrust agency. This does not have a legal binding nature, but it brings judges an important perspective. When you talk about excessive charging of royalties, ill-faith litigation, coercion, the CAD analyzed this and said, in the case of Ericsson, there is a negotiation of the licensee which has been dragging on for too long. Since the licensee has made this be delayed, we should not just look at the licensor or those who have the rights to negotiate a FRAN license under pre-established terms. The licensee also has to respond within a reasonable span of time. We cannot just wait for this answer indefinitely. And in this case, it has not been proven that the royalties of Ericsson were abusive and did not comply with the FRAN license. This will be done on a case-by-case basis. This has specialized courts in São Paulo. There will be in Rio de Janeiro next year. There's a favorable side, which is the harmonization of case law. There are judges that do not know this matter. I was making a joke outside saying that some judges do not know the difference between trademarks and patents, so we will have to deal with different difficult cases of all kinds of nature. So you can see how difficult it is for a judge to arrive at a sentence. I remember when I was trying a case with a lawyer who was saying, you understand the fact that cows commit suicide. I looked at Wagner and said, well, I've never heard about that. I mean, I know nothing about cows, and so I don't either. So we have to start learning about it. So a judge does not know these things, and judges cannot know about all topics. So I know that sometimes lawyers say, well, the judges do not want to hear lawyers, but I think that this is fundamental. I think the judges have to talk to lawyers. So try to make an oral argument when possible and explain these things to judges because they don't know. And here are some bits of some sentences. Some of them are in a legal secrecy. I don't understand why, because patents are public. Lawyers understand this better than I do. There's This is a decision of the 13th Court, Judge Masanuni, saying that granting of patent is not submitted to any limitations by an INPI, and once the essentiality of a patent is recognized, INPI does not need to state that a patent is essential. This is another decision by the Fifth Court in Rio de Janeiro, and this is how judges have been analyzing these issues of essential patents. The inventor has a patent letter and has rights given by INPI. There's a territory, and when enforced, the author brings an opinion saying that that patent is being infringed in the market by a third party, and the injunction is granted to prevent the sale and distribution of those products out in the market. Judges believe that in face of this scenario, this is the situation, and they grant injunctions, often without listening to the other party. So this is how judges have been acting, and I admit this is the first time that I saw myself in a situation of an essential patent. It wasn't in my court, but talking to colleagues, there was a judge who said, "Flavia, do you know anything about patents? I have a request for an injunction. The person proves it has a patent and there is an infringement in the market, and so what do? I have to grant an infringement." But this is not quite so. Maybe you have to grant an injunction, maybe not. And the essential patent shows this difference. Interestingly, in this case, the defendant said that the corporation was not complying with obligations, but this was not proven after further examination. So you have to look at this on a case-by-case basis. At the Fifth Court in Rio de Janeiro, there are specialized courts, as I said, and lawyers know that the judges know the matter. So the analysis of an essential patent is being incorporated by these judges. Now, coming to a close, there's this decision by Fernando, who is a judge that I like very much, from the Business Court of Rio de Janeiro number 7, and he says that the judge can stop the damage in 24 hours and withdraw products from the market, establish a fine if products are sold. But the most interesting bit is when this company distributed this in Rio de Janeiro, it made a distinction of why these patents were essential, and the distinction was only one. In some cases, it has SSO self-declaration. In other cases, it declared itself, and this is why it distributed to different judges regarding different suits. And judges have been basing the injunction analysis on opinions by engineers and experts and university professors. And it suffices that these engineers say, in fact, this third party is infringing this essential patent, and the judges have been granting injunctions on those bases. This is from a court in São Paulo, which I shall not praise, although I am in São Paulo. This is the Court of Justice of São Paulo. The judge said the evidence of the violations, we have to stop this practice immediately because it is violating industrial property. But this is not quite so. You have to make an in-depth analysis if you're a judge before granting an injunction. And this is also a judge in Sao Paulo, in Rio de Janeiro. It's not just Sao Paulo that is to blame. There is a patent letter, there's a violation, and an injunction is granted. This is the last slide. I hope I'm not tiring you. There is no legal secrecy about this suit. This is why I brought it. There's a judge who is remarkable in Rio de Janeiro, Margaret, from the 18th court. This is her sentence. In this case, they have not heard the opposing party. There is a request to ban the sale of the products in the market. And telecommunication systems, I mean, it's about mobile communication. If you go from one place to another, your line won't go down. And then the author says that there are 5 competitors that use this technology. There are several opinions from different experts, and the claimant said that a license was requested to no avail before. 85 pages contesting this. Dear lawyers, how come you write 85 pages? For Christ's sake. I know that this is a difficult and controversial matter, but I mean, imagine a judge who has to read God knows what, huge amounts, and you write 85 pages? There's no way to speak so much about technology. You have to go straight to the point and have focus. I know that this is a difficult matter, but anyway. There were 2 lawyers, and both of them were so extensive. This is constantly seen in IP. And there are many arguments brought up. But then it says, well, this is a self-claimed essential patent. There's no contradiction. There's no proof. Things are not so simple. And then there's the sentence of the judge saying, to simplify it, you need to provide proof. Let us prevent this injunction war. Let us be sure about legal issues and understand who is entitled to what. And then she issues this sentence. I advise you to read it. This court in Rio de Janeiro is wonderful, thanks to Judge Margaret, and she's been pioneering these decisions. I have spoken much too much. I think I had never spoken so much in my life. Thank you very much. This is my email. If you would like to send me an email with criticism or suggestions, or more documents for me to read. Luis Enrique, since yesterday, sent me quite a few pieces. I bet that you're going to ask difficult questions, so I had to go through it all. I'm available to all of you, and I am sorry I went over my time. Thank you very much, Judge Flavia. Within such a short span of time, you managed to summarize such a complex topic. And you're a brilliant example of the Brazilian court system. We count on brilliant minds, and I hope that in the future we can establish the difference. Yeah, well, at least I know the difference between trademarks and patents. And about this issue of very long argumentation, I remember that at one point we had this difficult case for revising our ABPI decision, and we decided to write a preliminary argumentation of 300 pages, and our colleagues answered with 400 pages. And when we arrived at the reconciling audience, the judge says, I will not read this. You will come out of here with an agreement. You will not come out of here before you reach an agreement. And so it was done. Guilherme, do you read 300 pages? Nobody reads 300 pages. This is inhuman. So thank you very much for your excellent and brilliant presentation of both of you. And we will now take questions. I will ask the audience to pose their questions. We have Gabriel, and people who are online, you can post them. I can read them. Thank you very much. I was told to ask a question in Portuguese because there is simultaneous translation. Congratulations, Judge Flavia. I am going to ask a question to Nicholas, because then Judge Flavia will not committed to any kind of future sentences. My question, Nicholas, is about the burden of proof. How do you see in Germany and Europe the burden of proof regarding the terms of the license? Because Judge Flavia showed a decision by the Brazilian CADE. It was mentioned that the licensee did not prove that the terms provided were not unreasonable. Does it make sense to leave the burden of proof to the licensee? How do you see the issue of this being non-discriminatory? The patent holder would have the burden of showing other licenses that have already been granted to prove that it was non-discriminatory?
Honestly, it doesn't make much sense. If you consider general burden of proof rules, then you would say each party has to provide evidence for the claims that they are making. And if I, as a patent holder, I'm claiming that I'm providing a France license offer, then I would have to show that, of course. So for me, this is a general legal principle that is applicable here. It's not something that is particular to France cases. On the other hand, of course, also the implementer will also have to show, if he provides a counteroffer, that this counteroffer is France. But the implementer is at a worse position here, because the implementer often, he doesn't know the patents as well. He doesn't know the whole environment, the whole standard, as well as the patent holder, of course, who has been part of the process or has acquired patents which from a portfolio which was created with respect to the standard. So if at all, then it should be the implementer, in my personal opinion, it should be the implementer who may be able to claim that it should be the other party providing more detailed information on what is actually FRAND. And FRAND is always a corridor, so it may well be that both the offer and the counteroffer are FRAND, which is why the CJEU, European Court of Justice, derived with this 5-point checklist that ended with a bond agreement, notably. Yes, so in my honest opinion, it doesn't make much sense to have the burden of proof shifted on the implementer. Thank you.
Congratulations on the talks. Very interesting topic. Flavia, I wasn't going to say anything, but I'm going to have to. You made a really interesting comment on the specialization of cameras here in Rio, or chambers you're in Rio. We do have it the first instance, but not the second instance. So it's a very technical ruling at the first instance, but there is no such thing at the second instance. Is there anything concrete that will be happening under the current administration, or potentially it might not? And if it does, what would be the criteria of choice? Who's going to go to this expert chamber? And actually, I'd like to ask our chairman, Mr. Leonardo's, for the Brazilian Trademark Office to make your application official to be part of that chamber. And you're supposed to be my friend. We were talking about that yesterday. She said, I don't want it. I don't want it. Yeah, but I mean, you would have fewer cases. Yeah, but they would be much harder. Yes. Henrique does intend to do that. Specialization is a project of his administration, and Henrique would love to implement that and wants to do that. This will be voted on at the court this year, and as of February, Henrique would like to start the ball rolling. There have been studies on the distribution of cases to see if it's not going to be a mistake, as it was when we talked about the number of consumers. The number of consumers is 60%, so there was no justification for the specialization. I think it's justified now. Now, the way to choose it, I mean, we'll all put our names forward, and the specific agencies will look into it. At least that's what happens now. So anybody who wishes to do so, anybody who wishes to take part in these expert chambers will put their names forward. I just don't know if I agree with the time frame, because I think it will be 2 years, and the judges would be associated to these chambers. At least that's what they're thinking of. I think it would only make sense if it were for longer, but this will be debated. You know, judges love to debate such matters. Some people think this specialization is not the way forward. There are people who believe that, but, you know, I'm part of the current administration, so I'm with Judge Henrique, but I think the INPI should also put some names forward. I think it would be taken into consideration. It's not just IP. There are other matters to be considered. Recomposition is another one, but we're moving towards that. I don't think we can go back on it now, because I had the opportunity to talk to Judge Henrique about that, and he mentioned that the idea would be to choose the members according to their seniority. Yeah, that's how the courts usually work. Everything is based on seniority. And I said, but Judge, shouldn't it be someone who has taken part in events on the matter, or taken classes or courses on intellectual property, who has the knowledge? And as a segue, I would mention the term by the Supreme Court, paragraph 1, article 40, where 2 votes, Justices Fuchs and Barroso, had well-grounded votes, and they have always taken part in IP events. They know the subject, they know what it's all about. I think some level of specialization on the topic would be crucial. Yeah, but these people will join and they'll start specializing very, very quickly. I don't think that is a concern. If there is some kind of, I mean, if people are putting their names forward, potentially seniority could be a criterion. If many judges are interested, I heard that their qualification and their CV would be taken into account. I don't know if that's going to happen, because the idea really is to acquire that knowledge from then on. The courts really go on seniority, but I think maybe the Brazilian Trademark Office or another entity should do that. Okay. So we will ask our chairman to send a notification to the presiding judge to recommend some sort of qualification on the subject matter. Yes, that suggestion had been made, but I admit that I have my doubts, politically speaking, because I don't want to cause any offense. I mean, the judiciary branch shouldn't think that we are trying to intervene and meddle with things that are none of our business. You know, I'm very careful when it comes to politics. So I will keep it under advisement. Thank you. We have 5 minutes left. Do we have any further questions? Thank you. Right at the front here. Thank you. Actually, just a brief comment. I want to thank the speakers for the panel. It's been wonderful. And Judge Flavia, your comments have been most interesting, especially because we're talking about very complex technology. So this injunction war is something that needs to be explored, studied, because there are opinions presented by both parties, expert opinions presented by both parties, judges deciding that this is a very complex subject matter, but granting injunctions in situations where the patent holder alleges that there had been FRAND licenses, FRAND defenses by other companies, but cannot prove that there is such a license, that there is such a contract. So these injunctions are held all the way to the end without evidence. And where the ABPI has ruled on the invalidity of the patent. So there is a contradiction there, because the defendant is saying that there is no infringement, but at the same time, they brought a suit for the invalidity of the patent. So these are very complex issues, and we really do need to take an in-depth look at what's going on in other countries, because they have more consolidated rulings and more in-depth conversations, so that we can make the best use of our system. So thank you. Thank you for both the talks. Thank you for moderating the panel, Mr. Luis Henrique. Congratulations. Yeah, that's key. That's it. Nobody wins with this injunction war. It's bad for everyone. And for the plaintiff and the defendant also. I don't see any benefits from that. I confess. But it's a very new thing. Judges aren't familiar with the subject matters. They've only just started learning. There have been some interesting things coming from different instances, different courts. But it really does depend on the lawyers. You are lawyers who have very specific knowledge, and judges should listen to you. I have no doubt that the judiciary branch is only beginning to understand. But we can see in recent rulings that people are beginning to understand a bit more. And what I saw at first is that there is a valid patent letter, there's documents, and an opinion that there might be an infringement, so I will grant the injunction. That's a valid rationale. If we were dealing with simpler subject matters that are not addressing complex technologies and didn't require in-depth knowledge of the subject matter. So I have no question that the judiciary is becoming more sophisticated, fine-tuning the knowledge so that there can be more reasonable jurisprudence on the matter. Some people say, oh, that shouldn't be, I don't know what's going to happen in Brazil. I think, first of all, they find the jurisprudence, and then it will go to Congress. Because at the Congress, the legislative procedure isn't simple. I don't know how many bills there are to change the IP law in Congress. They've been there for years. There are lots of bills all over the place. They're trying to consolidate them. I have no doubt that specific initiatives on essential patents will end up as part of that all-encompassing projects that are in Congress right now. So I feel that first, we'll fine-tune the jurisprudence. We have a question here at the top. And you, Paula. You? Anyone else? No, Luis first, and then over to you. Once again, congratulations on the presentation. This is such an important topic. In talking about essential patents, and please correct me if I'm wrong, I think we're talking about less than 2% of the patents that are granted by the Brazilian Institute of Intellectual Property. So I'm very worried about this broad position because there are waves, and the wave of reviewing all patent letter, all the injunctions granted based on them, you know, with the allegation that that patent might or might not be essential, we're going to create a problem that is 98% bigger than what we have right now. Perhaps a way forward when it comes to essential patents might be to identify them. It would be much easier if we have a clearer position on which are the essential patents. I don't know what things are like in Germany, but the figures I've seen were very close to that, 2% tops. And in some specific sectors, like biotechnology, telecommunications, maybe those two areas cover 95% of those 2% we're talking about. So I'm worried about that. I think it's an important topic. I just wanted to make that comment, you know, about really having to identify which are the essential patents.
Okay, just coming back to Germany. Yes, I do think it's a small proportion of the patents overall granted, and we haven't seen this much in the bio sector, but we've of course seen a lot of in the field of technology, especially telecommunications. Coming back to the question, should we have a system that actually shows which patents are standard essential, and should we have that, for example, at the standard-setting organization? So should the standard-setting organization themselves declare which patents they consider relevant to the standard? I think that's a valid suggestion. But then again, that would also would be something that would that the legislator would have to address, I think. So it's hard for courts to make up a rule like that, I suppose.
So, yes, you're absolutely right to be concerned. We're not here discussing the 98% of patents. It's just that there are two ways of making patents essential. One of them is through an authority or an organization that will deem it so, or the whole industry will deem it so, or in some countries there is a self-declaration. Even the patent holder can do that. Either the patent holder states that that patent is essential and the authority can look into it and decide whether it's not, or they can self-declare, and then during the action they decide whether it is. For regular patents, I mean, we're not talking about that. This panel is specifically about specific cases where either the party self-declared the patent as essential, or they've already offered the patent as essential, and there will be an authority who's validated that. So if there is no such discussion, then we shouldn't talk about essentiality or not. Yeah, exactly. Of course, we always think it would be so great if there was a provision in the law for that. We love that because it solves all problems. But IP is difficult, but because it's subjective. There's always a subjective aspect when it comes to intellectual property. Even in trademarks, sometimes there's a registration by the ABPI granting that registration. And if it's unfair competition, each judge decides one way or another. Why do they decide differently? Because it's about how it's put forward. It's about how judges feel it. Justice Fuchs says that rulings sometimes are about a judge's sensitivity. You say, oh, judges are insensitive. No, they're not. Some are more sensitive than others, it's true, but they are sensitive. And essential patents, I mean, it would be great if there was some kind of regulation on essential patents, but the legal principles and the sources talking compulsory license, the antitrust legislation already provide us with some basic principles to judge on conflicts of interest. Erica's told me that time is up, so please be brief. I just wanted to say congratulations on the panel. Nicholas, Flavia, Luis, just to remind you, you've talked about the 300, 400 pages of the report so that we can avoid taking everything to the judicial level. The Brazilian Trademark Office is very much for arbitration. You need to use conflict resolution, so there's always that important solution. It's mediation in intellectual property. Congratulations again on the panel. Fantastic, great reminder. Thank you. Take everything to Caesar, please. Mediation. At the Brazilian Trade Office, we have a specific arbitration chamber just for intellectual property. So, yeah, great suggestion, Paulo. Thank you. All right. You can talk to Erica, because, she told me time is up. Flavia talked about trade secrets. Luis Henrique mentioned consolidation and jurisprudence. So with trade secrets, that consolidation becomes more complicated. So this is something to be reconsidered. We need to try and somehow deal with trade secrets that have been deferred. And as a segue, I have one last question to you.
How does this work in Germany? The secrecy of justice in the suits is usually respected.
So thank you for the very valuable question. Actually, this is a major consideration. And when we're talking about office or counter office in German proceedings, especially standard essential patent proceedings, litigation, then we always have NDAs in place between the parties. And then they can exchange under these NDAs the respective, for example, prior license agreements, for example, made by the patent holder with other licensees with respect to that particular patent. And also have a very relatively new trade secret law in Germany that also covers particularly proceedings, and we have a provision in the German Patent Act that incorporates these provisions into patent litigation proceedings. So we have a lot of protection also for the things we discuss in our briefs. And we always have two briefs. One brief is technical. So there we have our non-infringement arguments, for example, if we're the defendant, and we have our arguments regarding stay of proceedings, since we have always nullity action in parallel. And then second, we have a front brief, and that brief starts with a provision where we say what we all consider confidential, and the courts actually have to treat that as confidential. And so this isn't public, the public will have no knowledge of this. This is in a separate folder. We will have, in the oral proceedings, we will have a separate section where we discuss these issues. And then actually there's no argument for the plaintiff, for the patent holder, who generally raises these issues, left to not provide the detailed information on their offer and why they consider it front.
We have arrived at the end. We could remain here discussing this for a long time, but without a doubt, I think that we have managed to cover a whole series of topics and aspects regarding essential patents, and I would like to thank Nicholas so much for coming all the way from Germany to speak to us. Flavia, you came from Rio, you left the beach to be here with us. Thank you very much for being with us, for having studied all this for us. A round of applause to our lecturers, please.